I'm Skip Schweiss. I work for TD Ameritrade, and the reason I'm here is that we have a long-time affiliation with the Institute for the Fiduciary Standard. We're sponsors of Fiduciary September. I believe Knut and I were trying to think back last night. I believe this is our 5th year in a row. So honored to once again be a part of that. So thanks for having me and allowing me to moderate this event for Professor Langbein today. I want to acknowledge a few people. Rob, thank you very much once again for hosting us at dinner last night. I hope you'll share our appreciation with your wife, Tam. You have a beautiful home, and dinner was wonderful last night, so thank you. I got to know a few of you last night at dinner, and I found out I'm at a distinct disadvantage at this event that some of you have known Professor Langbein for decades. I heard some wonderful stories going way back, and I've known him now for 16 hours or something like that, but enjoyed our conversation at dinner last night as well, including hearing about your summers in Finland. That was interesting. Program overview. So we're kicking off now. I'll have a couple more minutes of introductory remarks. I'll turn it over to my friend Knut Rostad here shortly. Then we're going to hear from the Dean of the Law School. Excuse me, I left her bio over here. She will be arriving here in a few minutes. Dean Angela Onwuachi-Willig. Did I get that? Thank you for that tip. A couple of words on Dean Onwuachi-Willig. She's a renowned legal scholar and expert in critical race theory, employment discrimination, and family law, and joined the law school here as dean just over 1 year ago. Before her current stint, she served as Chancellor's Professor of Law at the University of California, Berkeley School of Law. She is the author of According to Our Hearts, Rhinelander versus Rhinelander and the Law of the Multiracial Family. Recipient of numerous awards, including the Association of American Law Schools Clyde Ferguson Award in 2015, the AALS Derek Bell Award in 2006, the Gertrude Rush Award in 2016 from the Iowa Organization of Women Attorneys and the Iowa chapter of the National Bar Association, as well as Law and Society's John Hope Franklin Jr. Prize in 2018. Quite distinguished, and she will be with us in just a few minutes. I'd like to go through our program. I think you may have it in front of you, but we're kicking off now. In a few minutes, John will come up and begin sharing some thoughts with us. Looking forward to that as part one of the seminar. We are going to break. One of my primary jobs up here today is to keep the trains running on time. I don't think that will be difficult. Number one, I'm German, and number two, I'm in a room of academics whom I know work on the clock. So I think that will work out just fine. At 12:15, we'll break. I see they're bringing our meals around now. We'll take a short break. We'll pick up our lunches. We'll get back to our seats and return to our seminar with John. We'll conclude that at 1:15 and then go on to our award presentation and acceptance to conclude our afternoon. Couple more notes before I turn it over to Knut. We do have a couple members of the media present. So welcome, Bob, and welcome, Christopher. Lastly, I will be also facilitating Q&A. And since we are recording this, we will need your questions recorded on this microphone. So ask them, raise your hand as you're ready, and I will get the microphone to you so we can capture the question, and then John, of course, can respond to that question. So I believe that concludes my opening. Knut, are you ready to take over? Thank you.
Thank you, Skip. Is that coming through? All right. I'm just going to take a couple minutes, maybe 3 or 4, to say a little bit about the Institute and suggest the special significance of where we are regarding fiduciary in 2019. The Institute was formed in 2011 to provide policy commentary, education, and advocacy on fiduciary duties and investment advice and financial planning. The Institute is the only nonprofit that we are aware of solely dedicated to advancing fiduciary duties in the context of the conduct of brokers and investment advisors. The Institute offers real fiduciary practices for advisors who are seeking guidance on what this should mean, and puts out white papers. We have commented on the SEC proposed Department of Labor rule that was in play for several years. We've commented on the SEC and state rules as well. We are grateful as an organization to have former SEC Commissioner Luis Aguilar and Assistant Secretary of the Department of Labor Phyllis Borsey to serve among our advisors to the Institute. The Frankel Fiduciary Prize was established to acknowledge individuals who have made significant contributions to the preservation and advancement of fiduciary principles in public life. The prize is named, of course, in honor of Professor Frankel, who is here with us today. The Frankel Fiduciary Committee is proud of this program that we have today. Robust discussion and the meaning of fiduciary carries consequences, as we have been reminded for literally generations by Harlan Fiske Stone, who opined in 1934 about the failure to observe the fiduciary principle will come to explain the prior few years, in his humble, modest opinion. 2019 has important meaning for federal fiduciary duties for brokers and advisors. It's 20 years this year, in fact, since the SEC proposed a rule to let brokers offer fee-based accounts without being subject to the Investment Advisors Act. And it's been exactly 10 years this year since the Obama administration called for broker recommendations to be held to a fiduciary duty. And then this year, on July 5th, the SEC released 4 rulemakings. 2 stand out. Regulation Best Interest seeks to raise the standard of brokers. The interpretation of the standard of the Investment Advisors Act, released 5248, seeks to clarify certain aspects of the Act for federal fiduciary duty. Just a couple of comments about each of these to come to, I think, an important point. On Release 5428, 12 concerned securities law professors, led by Columbia's Jack Coffey, found, quote, the Commission has turned its back on its history and reinterpreted case law in a surprising manner that reverses what it said only a year ago, unquote. And then, as noted by the professors, last year, the SEC stated the law requires an IA to put its client's interests first. Now, the concerned 12 observed this year the SEC says an advisor must not subordinate its client's interests to its own. The concerned 12, that's my phrase for the group of professors, call this a very weak substitute. They also chide the SEC for relying on the Supreme Court 1963 capital gains case when, at the same time, the SEC then reinterprets the Investment Advisors Act. The concerned 12, and this is their word, not mine, calls this reinterpretation bizarre. On Reg BI, the SEC calls the rule an enhanced standard for brokers that meets investor reasonable expectations. Still, many beg to differ. The comments of Reg BI have been broad and deep and in some cases fundamental to its core. The list of concerned groups is long and it's quite well known. The SEC presses on. It has started a public conversation and tries to address key concerns. This much is good and is much needed. Then, however, it levies a general criticism of the critics. Quote, much of the criticism is, quote, false, misleading, misguided, unquote. according to this broad criticism by the SEC. This statement is unfortunate. It is a blanket criticism that fails to add insight to or understanding of Reg BI or the Advisors Act. This statement is also curious given the securities experts, the advisors groups, the state securities administrators, investor advocates, and investors themselves who have expressed significant and good faith concerns about the rule, or given the fact that Massachusetts and New Jersey have pressed ahead, in large part because of the SEC rule, to come up with their own state fiduciary rule, or that 7 attorneys generals in the District of Columbia just last week have gone to court to challenge the rule, the Reg BI. Ironically, if you look at the SEC's own research of investors, you can find in there deep concerns expressed by investors as well. So, whether you start in 2009 or 1999, or in fact centuries ago, in a sense, the SEC 2019 rulemaking culminates recent actions that seek to trump lessons of history. The 2019 rulemaking upends the Advisors Act, while it brands brokers as advisors without the attendant duties. And again, this isn't just my view, it's a view held by a wide variety of organizations and experts and law professors who have been taking note. So the importance today, it is a stark reminder of rulemaking without the benefit of robust legal and policy discussion. And in my view, it's a stark reminder of why we are here today.
I'm Angela Onwuachi-Willig. I'm the Dean of the Law School. I just wanted to welcome you to Boston, welcome you to our wonderful law school, our beautiful building. I want to extend my gratitude to my colleague, Tamar Frankel, who is a force of nature, I'm sure, as you all know. But she's also really a true pioneer. She was the first woman on the faculty and really broke down a lot of barriers for people like me to be in this position. And so grateful to her for all of her work there. And then more importantly, for this group who is also the intellectual godmother of the fiduciary rule. She has brought widespread glory and recognition for BU Law as a pioneer and expert on financial regulation and fiduciary obligations, and she's really helped to transform the field. And so we're delighted that you recognize her contributions every year by awarding the Frankel Fiduciary Prize to an incredible scholar who's made key contributions to the field. With that, I want to extend my warmest congratulations to Professor John Langbein from Yale Law School, who's a leading authority on fiduciary law and a distinguished scholar of legal history. Professor Langbein, we want to thank you for your transformative scholarship, your continuous service as a Uniform Law Commissioner since 1984, your work as a reporter and principal drafter for the Uniform Prudent Investor Act, and a lot more, much more. It's too much for me to really name, but I want to thank you all for coming to BU Law to honor Professor Langbein through this award. And again, of course, I extend my gratitude to my wonderful colleague, Tamar Frankel. I really hope that you have a great meeting, a great time, and best wishes. Thank you.
So one more note on me. A few of you asked me last night where I come in from. I'm from Denver. TD Ameritrade has its trust company in Denver where we provide custodial and directed trustee services for retirement plans of corporations, governments, and nonprofits. And I've also been involved for the last 9+ years in advocating for higher standards of care for investors, helping investors understand distinctions between broker-dealers and investment advisors, and lots of work like that, including on Capitol Hill in Washington. On a personal note, I'm also a trustee of a family trust, so I think I have lots to learn today from Professor Langbein, and look forward to it. Professor John Langbein.
What I wanted to say about Skip's remarks is that there has been a profound change in the way in which investment takes place for tens of millions of people. And that has to do with the shift from the defined benefit pension plan to the defined contribution plan. The old defined benefit plan, which is now largely archaic. There are still some that are in operation, but they are being wound down and no new ones have been started in years. The old defined benefit plan was one in which the employer promised the employee and his or her spouse a lifetime income in retirement, and according to a formula. And the responsibility for getting the money in place to pay that was the responsibility of the employer. And therefore, when it came time to invest the contributions that the employer was making, and that in some cases the employee, it was the treasurer of General Motors or whoever the employer was who was making those decisions. There was a serious, sophisticated investment professional in charge of making the investment decisions. What has happened in consequence of the shift away from defined benefit plans to defined contribution plans, what has happened is that every worker on the shop floor is now his or her own investment manager. And the difficulty with that is he or she doesn't know anything about investing and should not be faulted for not knowing anything about investing. It's a very sophisticated world out there. So what we now have is a new world in which we have tens of millions of people making decisions about how to invest their retirement assets. And when you have people who don't know anything about what they're doing, you have trouble. The danger is that they will be misled. And therefore, part of the impetus for organizations like the Institute and for many other steps going on at the moment, and the impetus is to prevent serious abuse in the investment process. The right answer is, in my view, utterly clear. And that answer is, if you are acting as an advisor on investment matters to somebody who doesn't know anything about it, and if you therefore know or ought to know that that person is relying upon your advice to be in that person's interest, you are a fiduciary for making sure that it is in his interest. You have a duty to advise in a way which is sensible, that's the prudence norm, and which is oriented to the interest of that person. And it is amazing how hard some forces in the investment world have resisted the imposition of those duties. On the other hand, it is, in my view, really gratifying to see the extent to which people in the investment industry, including the folks who have come together to form the Institute, and others, have insisted on the importance of this fiduciary role. It is people aren't always selfish, and in deciding to recognize that fiduciary role, you folks in the Institute are really doing the right thing, and it's a credit to the industry that you are doing it. That's not what I'm here to talk about. Let me talk about my announced topic. This topic I've been mulling for a long time, and I thought since I'd be in the presence of some investment professionals and some serious academics and law folks, that maybe if I set this topic up, I could have a discussion with you and learn a lot. The topic that I want to discuss concerns what we call the trust law duty of loyalty. The black letter, the restatement says that this is the duty to administer the trust solely in the interest of the beneficiaries. If you are a fiduciary, in particular, if you're a trustee for somebody else, you have to administer that trust for that person's exclusive or sole benefit. You may not take into account your own self-interest. This is a very noble principle. Most of the time in transactional life, we have a different standard, which is you can be as selfish as you want, sharp elbows, as long as you don't commit fraud or something like that. You have a right to be self-serving. Not, however, as a trustee. As a trustee, that fiduciary duty of loyalty cuts in. It is often described in the scholarly literature as the most fundamental rule of trust law. It has been traditionally expressed as a duty. Let me read you the restatement version. It's a duty to abstain, quote, from engaging in transactions that involve self-dealing or that otherwise involve or create a conflict between the trustee's fiduciary duties and personal interests. It's your duty to avoid creating the conflict. That's the core value. A trustee who violates that duty is subjected to what is known as the no further inquiry rule. It's a rule that says that if you have used your position as trustee to create a conflict or to engage in self-dealing transaction, if you have acted in this fashion, the law will not listen, will not entertain a defense based upon the merits. You are not allowed to explain why you think this might have benefited the beneficiary. It's simply per se forbidden. That no further inquiry rule can be very harsh. I, the trustee who engaged in a transaction in which there was some benefit for me, may have had motives pure as the driven snow. I may have thought that this was going to benefit you, the beneficiary. I might be able to show that we are both better off when I benefit. Not allowed even to present the argument. The no further inquiry rule says no inquiry. And that rule has been in effect for a couple of centuries at least. It's a remarkably harsh rule. I have elsewhere criticized it. My own view is that we could be a little less harsh in these circumstances, but that's not what I want to talk about today. The no further inquiry rule is there, and it's American black letter. Its purpose is basically prophylactic or penal deterrent. The idea is that if you are put on notice by trust law from the start that you are not going to be allowed to defend effectively on the merits what you did when you lined your own pocket, you will not be tempted to try. you will therefore keep your hands out of the trust funds when dealing with somebody else's beneficial interest. That's the theory. In practice, despite the sole interest rule and the no further inquiry principle that enforces it, despite that, we have an enormous amount of conflicted trustee activity. Routine trust administration abounds with conflicts of interest. And they occur despite the no further inquiry rule. They occur because the duty of loyalty and the sole interest rule, the no further inquiry rule, those principles are default law. They are rules which can be varied, can be altered by the settlor of the trust when creating the trust by providing contrary terms. Let me give you a few examples of the circumstances in which this sort of thing happens. Consider, for example, cases in which the settlor names a conflicted person to serve as trustee. My favorite example of this is one which I was involved, my father's estate. But the pattern, it's a routine pattern in family succession arrangements. For one spouse to create a trust which provides life interest, life support for the surviving spouse, and the remainder for the children. Completely ordinary family provision trust. Frequently in such cases, and this was the case in my father's estate plan, the settlor of the trust names one of the children, in my case me, as the trustee. In that situation, the trustee is in hopeless conflict. Any decision that I made with, I'm sorry, maybe it's a margin call. You know, my wife makes me carry this thing, and I'll be darned if. All right. Okay, I think I just disabled it. Back to my situation. In administering that trust, I have decision-making authority about the investments, and I may, under the terms of the trust, have what's called a power to invade, which is the ability to go into the assets of the trust, the corpus we call it, and make further distributions to the to my mother, the life beneficiary. Every decision I make in that case is one which is conflicted. Every investment decision is conflicted because the decision that I make with respect to the type of investment and the degree of risk to bear, that decision is one which will affect the payout to the income interest of the trust. Likewise, my decision to exercise the power to invade. If my mother needs more money than the life interest than the current income interest is supplying. In that circumstance, I have discretion to invade the trust corpus and pay it out to her right now. Trouble is, if I do that, I am diminishing the remainder interest, which will come to me after her death. My father created that conflict. He trusted me to handle it well, but and I did. Needless to say, I did not beggar my mother. I saw to it that she did well. But that type of conflict is pervasive when the trustee, him or herself, is the remainder beneficiary of the trust. The trustee in that case cannot observe the baseline rule from the restatement that I just quoted to you, the duty of loyalty. Let me read it again. It's to refrain from, quote, engaging in transactions that involve self-dealing or that otherwise involve or create a conflict between the trustee's fiduciary duties and personal interests. There's no way that that trustee can avoid that conflict. The conflict is structural. And the question I want to ask about today is what is the fiduciary duty of loyalty of a trustee who cannot avoid the conflict? The easy question, and that's the one that the restatement deals with, the easy question is avoid the conflict. That's great. Most of the time, that's what you should do, and you can do it. But in these situations of structural conflict, that answer is not available to you. Instead, you have to act in conflict. Structural conflicts arise in many settings. Some of them arise on account of express authorization in the trust instrument. The restatement talks about the example that the terms, I'm quoting, of a trust may permit the trustee personally to purchase trust property or borrow trust funds or to sell particular property to the trust. Things of that sort. Steps which would otherwise be forbidden can be expressly authorized. When the trustee is a bank or other corporate fiduciary, legislation expressly authorizes certain transaction types that would otherwise be forbidden conflicts. Examples include statutes that allow the deposit of trust funds in a bank trustee's commercial banking division. So if my trustee is J.P. Morgan, J.P. Morgan does not have to have the trust banking account across the street in Bank of America. Instead, you can engage in self-deposit. If you do it prudently, you have to put the funds in an interest-bearing account if they're available and things of that sort. But you can engage in this conflicted conduct. It was forbidden until the last 50 years or so. And there's been a trend by legislation, now codified in the restatement and the Uniform Probate Code, the Uniform Trust Code. There's been a trend to allow self-deposit. It's an obvious convenience. These sums are relatively trivial, and the thought is that the gain outweighs the danger. A much more important example is legislation which is enacted in virtually all states now, and in the Uniform Trust Code, When we were drafting the code, Ray Young was quite opposed to these provisions. The legislation which allows the trustee to use mutual funds or other pooling vehicles sponsored by the trust company, operated by the trust company, or by an affiliated entity. So if Bank of America is my trustee, Bank of America can, depending on where the particular branch is located and the like, Bank of America can invest the trust proceeds in mutual funds being offered by a subsidiary of the Bank of America Corporation. Open and shut conflict of interest, they're going to get fee income from the operation of that mutual fund. Why do we allow it? There are some reasons. Ray doesn't think they're good enough. I thought they were. Basically what's happened is that we have now moved to a world in which the trustee rarely constructs a portfolio of individual assets, 100 shares of IBM, 100 shares of AT&T. That doesn't happen anymore. We increasingly locate the investment. We increasingly use a pooled device because it will have huge economies of scale, and mutual funds constitute the modern pooling device. If the settlor who created the trust wanted Bank of America to operate the investment function when creating the trust, then the argument goes, the modern way of doing that is a mutual fund, and therefore you ought to allow them to do it in the mutual fund form as opposed to the individually constructed portfolio. So a very serious conflict of interest is authorized by law. How does the trustee in that conflict situation proceed? That's the question that I wanted to raise with you. I should say at the outset that careful drafting can often cause these problems to be diminished or eliminated. So this is an area where good lawyering matters. For example, in that trust for my mother, in which I'm the trustee and the remainderman, in that case, guidance in the instrument, the trust instrument, about its purposes can be minimize or eliminate the conflict. If that trust instrument says the primary beneficiary is my mother, anything left over is for you, but err in favor of the life tenant, you have given guidance of a sort which can help to narrow the potential conflict. So there's a lot of drafting wisdom in this area, and it's important when setting up one of these things to remember it. Another area in which we find endemic conflict is in ERISA, the pension regulatory statute. They have there's a large body of law dealing with benefit denials. So the health plan that is ERISA covered provides that it will not cover experimental treatments. Great. What's experimental? Is the latest thing that's only offered by one drug company as opposed to 6 others, is that experimental or not? Well, the decision maker in that case, guess what, in ERISA is allowed to be the employer who is funding the plan, and therefore is in a direct conflict. When these issues first started coming up in the 1980s, there was a notable Third Circuit case in which Ed Becker, the late Third Circuit justice, remarked that in these cases, I'm quoting him, every dollar saved by denying the employee's claim for plan benefits is a dollar in the employer's pocket. ERISA did not think this issue through, and so we have conflicted decision-making going on incessantly in the ERISA fiduciary area. So, I'll stop giving examples. Let me just say that the takeaway here is that although the baseline duty of loyalty requires the trustee to act solely in the interest of the beneficiaries and to refrain from engaging in transactions that involve self-dealing or other conflicts, situations of authorized or structural conflict abound. That's the reality. What then are the duties of the conflicted trustee? How do you manage the conflict? Our leading doctrinal authorities, but the restatement and the Uniform Trust Code, do not offer much guidance here, and they focus on the easy question, which is the duty to avoid creating conflicts, and they don't speak to the question, what do you do when you're in one? I'm hoping that we can make some progress thinking about that, and that the next time the ALI gets around to restating the law of trusts, that it will provide some serious guidance on this. The starting point, what I would call Rule 1 of conflicted trusteeship, is to recognize that the duty of loyalty abides. It's still there, but it cannot take the conventional form of the sole interest rule, and it also cannot tolerate the no further inquiry principle. There has to be inquiry. The trustee who's in an authorized conflict cannot be prevented from taking the steps that were authorized. Therefore, the logic of no further inquiry, which is to keep the trustee from creating the conflict, is not in the case. Even though the duty of loyalty abides, it still applies. In these cases of authorized conflict, the standard of loyalty is different. Neither the sole interest rule nor the no further inquiry principle can pertain. When the terms or the structure of the trust import the conflict, the duty of loyalty cannot take the form of a duty to act solely in the interests of the beneficiary. And in those circumstances, no further inquiry cannot apply because the trustee's claim that the conflict was authorized has to be the subject of inquiry, that the trustee's conduct was appropriate to the authority that is being invoked. How should a trustee that finds itself in such a structural conflict, how should that trustee proceed to discharge its surviving duty of loyalty and minimize the risk of being found liable for breach of trust? There are some potential moves that are open to the trustee in that situation. Let me tick off the ones that I presently am sensitive to and ask those of you with exposure here to tell me what I'm missing. Start with simple disclosure, the mother's milk of trusteeship. Disclose, disclose, disclose. Whenever in doubt, disclose. A conflicted trustee should inform the beneficiaries regarding the nature, circumstances of a potentially conflicted transaction, usually in advance, and therefore avoid any claim of concealment, of sharp practice. Let the beneficiary know before you do it what the transaction in question is and why you're doing it. That puts the beneficiary on notice that if there's dissent, the time to protest is at hand. That's a procedural step, but I think it's an easy one in the trust tradition. Another step that is in theory open to a conflicted trustee who wishes clarification or protection of a potential transaction, of its legality, whether it's within the scope of his authority. That step is to seek judicial instruction. One of the unique features of the equity tradition out of which trust law was developed was that equity stood ready to provide guidance to a trustee so that the trustee would not have to act at his or her peril. If you were in genuine doubt, you could go to the chancellor in the exchequer, in the chancery court, the equity court, and seek guidance. That power is codified in the restatement of trusts and in the remedy provisions of the Uniform Trust Code. We carry it forward. It was particularly significant in the days before professional trusteeships. Trust law for its first centuries was dealing with volunteers who served unpaid. It was an activity that a gentleman engaged in as a matter of honor and was not compensated. Indeed, English law to this day, the default rule still does not allow a trustee to be compensated. And if a trustee wants to be compensated, and professional trustees, after all, are in the business to earn a living and have to be compensated, that term has to be expressly provided in the instrument, and it has the effect of defeating the underlying default rule, which is no compensation. In those circumstances, you can see why, if you're dealing just with an amateur gentleman trustee, my brother-in-law is the trustee, or my clergyman. In those circumstances, you can understand why the tradition was, let him, if you have a doubt, you don't have to act at your peril. You can come to court and get some guidance. We have carried that over in the modern authorities, even though our trustee is ever more a fee-paid professional rather than the brother-in-law. This channel of relief is, however, not fail-safe. There are circumstances in which the time demands or the publicity of judicial proceedings is incompatible with the timing or character of the transaction in question. There are circumstances in which the trustee is offered participation in a deal, but the deal is closing within the next 20 days. You can't get that kind of relief from a probate court. It's just the timing is off. There are times when the terms of the transaction have to remain confidential under the terms of whatever the offering is. So there are transactions whose type does not lend itself to the power to seek instruction. More seriously, the courts are uneasy about advisory jurisdiction. They don't like it. And the way they have reacted to the perpetuation of this authority is to create maybe it's a principle, certainly it's a rubric, which is, and I'm quoting the restatement version of it, if a matter rests within the sound discretion of the trustee, or is a matter of business judgment, the court ordinarily will not instruct the trustee how to exercise that discretion or judgment. So you can see the problem here. The trustee's ability to get an instruction is limited to what in this circumstance is called questions of law, but what the trustee typically wants to know is whether a particular transaction or a particular distribution is within the terms of the trust or is within his discretion. And a rubric of the sort that I just read you from the restatement allows the court basically to take a pass and not be there when the trustee needs him. So the takeaway here is there is a power to seek judicial instruction, but it's hard to bank on it in many of the circumstances in which you need it. Another path, which is a little bit resemblant, is to for the trustee to try to delegate the decision to a court-appointed substitute decision maker who would not have the same conflict. So in the example I gave you of the trust where the primary beneficiary is my mother and I'm the remainder beneficiary, in that situation, if I go to court and have them appoint, say, Tamar Frankel as the trustee, it's not her mother, it's not, and I'm not related to her. She doesn't have the same conflict because she's not going to be a remainder beneficiary. That is an attractive solution. Trouble is, and it's endorsed in the restatement and in the Uniform Trust Code. The trouble with this use of a substitute decision maker, the restatement, Ed Hallback was fond of calling this function appointing a trustee ad litem, a substitute decision maker for the particular issue. The trouble with this is that it's rarely done. And if you think about it, the reason's pretty obvious. If the conflicted trustee recommends the substitute, I'm in this conflict and I go to court and I say, I want to have this decision whether or not to invade corpus for the benefit of my mother. I want to have it made by somebody else. And the person I think ought to make it is Tamar Frankel. Would you please appoint her as the trustee ad litem? The question then is raised, Why did I pick her? Was she really that independent? And as a result, I may not really escape responsibility for the decision of the person whom I recommended. If, on the other hand, I'm aware of that danger and I say to the court, I can't recommend anybody lest my bona fides in that recommendation be challenged. Therefore, I ask you to make the appointment without recommendation from me. In that case, I have basically just dumped my trusteeship onto the court, and it is open to a beneficiary who feels him or herself harmed by the decisions of that substitute to complain of my abdication of my trusteeship, to argue that I had no business making that delegation. A variant on the trustee ad litem idea is not to delegate the trusteeship, but instead to bring in independent counsel to guide me, the trustee, in my decision making. This was suggested most prominently by Henry Friendly in the leading ERISA fiduciary case, Donovan and Beerworth, which involved a takeover contest in which the trustees of the pension plan were conflicted. They were corporate officers, and depending on how they handled the the pension plan's holdings of company stock, they could be protecting their jobs or voting themselves out. And so this was a very serious conflict. And Friendly said, in reviewing their conduct, that he thought that they should have consulted independent counsel. The same time, he said, but I know that this is basically futile. It's not going to do any good. The reason is, when I seek independent counsel, there's a reason why the independent counsel I seek is Sullivan and Cromwell as opposed to Ropes and Gray. And it's because I know the guys at Sullivan and Cromwell, and they're not gonna make life hard for me. So in other words, there's a real question whether seeking independent counsel means you'll find it. The restatement has a passage in its prudence discussion dealing with advice of counsel. And it's a very sound provision. And what it says is, very simply, seeking advice of counsel is highly probative of prudence. A. B, it's never conclusive. Because if we made it conclusive, if we said he who seeks counsel gets a free pass, you create an incentive to basically to find a bad lawyer or to find a corrupt one. You can't give that free pass. And so the question then arises constantly: did I find the right lawyer? And that's not a happy question. It's not going to be much of a solution to these problems. That's my list. That's my list of known responses to this question. And I would be awfully grateful if in discussion here you could help me lengthen that list. I've got a nice yellow pad up here which I'm waiting to fill up with suggestions. So I'm going to conclude. I want to say that I have tried to deliver a four-part message here. Part one: notwithstanding the duty of trustees to avoid creating conflicts of interest, such conflicts are ubiquitous in practice because they so commonly inhere in the terms or the structure of the trust. Second, the conventional standards of the trust law duty of loyalty, namely the sole interest rule and the no further inquiry principle, these standards do not pertain in cases of structural conflict. That is the point that I would wish to see encapsulated in black letter the next time the ALI gets around to restating trust law. Third, even though the sole interest rule and the no further inquiry principle are not in force in cases of structural conflict, the duty of loyalty abides. The conflicted trustee has to give due regard to the interests of the beneficiaries. And finally, fourth, trust law contains a number of devices that can sometimes enable a conflicted trustee to avoid or to moderate the extent of the conflict. The trustee's duty of prudent administration, that is, the trustee's duty to exercise appropriate skill, care, caution in administering the trust, that duty counsels constant attention to whether any of these moderating devices might be of use in the particular conflicted trusteeship. Questions, welcome.
This may be an appropriate point for us to grab our lunches, consider questions, and come back to you with that. Thank you, John.